Good morning, everyone. This is the Board of Appeals meeting, May 12th, 2023, being held at the Planning Department Conference Room in Hilo, Hawaii, and also virtually using the Zoom platform. First, I'd like to introduce the members of the Board of Appeals. Present today is myself, Stacy Aguiar, Vice Chair Richard Henderson, who is appearing via Zoom. Board member Noe Saiki, also appearing via Zoom, and board member Scott Martin here with us in the planning conference room. Also present is our Deputy Corporation Counsel, Sherry Tavares, the board's attorney, April Supernon, our staff to the Board of Appeals, and Kim Tanaka, Secretary to the Secretary to the Board of Appeals, apologies. Just some general housekeeping, if we could just review some in-person and online protocols. If everyone could please mute or silence your mobile devices. And for online participants, all cameras must be turned on at all times during the hearing. One person speaks at a time with no side conversations. Mute your device when you're not speaking to improve audio quality for all. Raise your hand and wait for recognition before speaking to ensure we make a clean and clear record. And prior to speaking, if you could please state your name and let all parties know who you are before you start speaking. Speak slowly, clearly, and be close to your microphone. Limit distractions, i.e. turn off your mobile device. At this time, the board will take any statements from the public on items on the agenda. And we have no public testifiers today. So that closes the public testimony portion of this meeting. And if I may read in agenda number 1 under old business, 88-129 Kai LLC, PLBOA 2022-000048, findings of fact, conclusions of law, decision in order to deny appeal of decision by the Director of Public Works dated October 6, 2022 regarding revocation of building permit BK 2020-00049, location 88-129 Kai Avenue, Captain Cook, Hawaii 96704, TMK 3-8-005-101-0000. Kim, do we have any public testifiers on this agenda item?
No, we do not. Thank you, Madam Chair. Just for the record, I think you accidentally may have said 00049, but it should be 48.
Oh, got it. Oh, the permit is 49.
Yeah. Oh, the permit is 49.
So,
okay, very good. Apologies.
No problem. So to clarify, it's BOA case number PL-BOA-2022-000048. Okay. So if I can have all parties state their name and their appearance, and if we could start with the appellant.
My name is Christy Logan, and I'm here today.
Thank you. And we have Mr. Osmond, your appellant, attending via Zoom. And for the county?
Just for the record, Chrissy Logan is here for Kai LLC, the appellant. My name is Sinclair Solis Ferguson. I'm here on behalf of the appellee, Stephen Pawsey, Department of Public Works, County of Hawaii.
Thank you. So for the record, the board has received the following documents. Number 1, the findings of fact, conclusion of law, and decision in order from the Director of Public Works, and document number 2, concurring findings of fact, conclusions of law, and decision in order from the appellant. So board members, we are here today for the purpose of adopting an order affirming the Director of Public Works decision as decided by this board on April 14th, 2023. What we have before us for consideration are those two following documents. Document 1 from the Director of Public Works, findings of fact, conclusions of law, and decision in order. And from the appellant, concurring findings of fact, conclusions of law, decision and order. Do we have any comments or discussion by the board? And if I just may tee this up to remind the board, that Rule 3-20 states that the board shall not reconsider its actions in any contested case hearing after the effective date of the board's decision, meaning we voted on it in last session. So if we would like to start any discussion on the two documents before us, and or if no discussion, I'm looking for a motion.
Chair, on behalf of DPW, is there an opportunity for either party to make any comments or verbal objections to the proposed findings of fact? Law, decision, order, add a correction.
Are we, let me confer with our court counsel. Is that allowable since we're in discussion right now? Mm-hmm. Okay. So I guess if the board members are okay, if I would allow each party a brief minute or two to address the board before we start our discussion on the two documents. And thank you. Starting with the county or the appellant?
Mr. Osmond.
Mr. Osmond.
Yeah.
And is Mr. Osmond going to speak on? Okay.
That's his plan.
Mr. Osmond, if you could introduce yourself. I'm assuming your camera's not operable at this time?
Yeah, my camera is for some reason not working and I can't figure out what's going on with it.
Okay, so see. Okay. Okay, thank you. So Mr. Osmond, before you start, the reminder of why you're getting 2 minutes to speak is not to relitigate your case. It is any comments regarding the two documents that are before us.
Correct.
So you may proceed. Okay.
So though I do not agree with the BOA's decision, which deprives me of my private property rights, I would like the final order to contain a more complete and accurate set of facts for a better understanding of the ambiguity and complexity of this situation. Namely, that a home was built on or around 1987, and though DPW alleges that they have no records of inspections, in 2022, the building chief wrote in an email to the county staff that there was a foundation inspection on the 1987 permit, but later denied that fact during sworn testimony. That the plumbing contractor signed off on the 1987 building permit pink slip, plumbing contractor line, that DPW must keep a complete and accurate record of all the transactions, and that in 2020, DPW issued a remodeling permit on the property, that an electrical permit for permanent power was issued under the 1987 building permit in June of last year, and a first electrical inspection was conducted in August of 2022. That a septic tank was installed in 2019 and the Department of Health signed off on it, that only the water catchment was going to be honored under the 2020 permit as per the building chief's email and request for information, though the building chief revoked that building permit. Furthermore, in reliance on the permits issued by the permitting authority, I incurred a tremendous cost that now seems to be a total loss. Lastly, that DPW's resolution, which is to pull an as-built permit up to current code, is impractical and impossible because this 1980s home cannot be brought to current code, and because it does not have an SMA certificate and is within the 25 feet from the shoreline, new permits cannot be obtained without first succeeding in getting a variance. And the last thing I would like to ask is what code is being used here? The current code was not in effect during the years that the building permit 1987 and the remodeling permit 2020 were issued. And I would like to have an answer on the code that is going to be applied here. Thank you.
Thank you for your comments, Mr. Osman. And Mr. Salas Ferguson?
Thank you, Chair. I just want to, I'll talk about the findings of facts, conclusion of the law submitted by the Department of Public Works first. I just have one.
Okay, sorry,
Yeah.
come a little closer,
Or should I
just
try
so
and?
we can,
I'm just gonna make sure that.
make sure we can hear you.
Okay.
We just want to make sure that you're connected. Yep. There we go.
Okay.
Okay, if I start?
Yes.
So I'm going to talk about the findings of facts, conclusions of law, decision and order submitted by the county first, and then the document submitted by the appellant second. So I just have one addition to the document submitted by the county, and that's on finding of fact number 6. I'd ask that if the board adopts, first I'd ask that the board adopt the document submitted by the county because I believe it reflects more accurately the evidence that was presented and the decision that was made. And so on finding of fact number 6, at the end of that, I would add a comma and write related to the 1987 permit there to make it clear that the structure did not receive any inspections from DPW related to that 1987 permit, because I think that's what the evidence showed during the hearing. Rule 3-18 allows each party to submit objections to the decision order submitted by the other side, and each side has 15 days, and that's why I asked that we be given an opportunity to provide objections. So I'm just going to go very quickly through the objections that I found in the appellant submission. So on number 2, it states that a home was built on a property under 1982 UBC. There was no evidence that the home was built under the 1982 Uniform Building Code. That was not in evidence. Generally, I would strike all of the according to the county because these are findings of facts adopted by this board. Number 4, it says that a plumbing contractor signed the building permit. That was not in evidence. If the building permit shows that somebody signed it, it doesn't show that it was a plumbing contractor. Number 5, the appellant states the county has no records for an electrical permit under the 87 permit because the Middle East area started receiving power from Hawaiʻi Electric in mid-1990s. That was not in evidence, and that was not something that was the board's decision. Number 8, the building chief on December 1st, 2022 sent an email to the building department staff saying that the original permit only had a foundation inspection. I think that misstates the evidence because that was explained by witness Julian Sonomura that was a mistake. Number 12, DPW issues permits in the county and does all due diligence prior to issuing a permit per Hawaii County Code Section 551A. That's not what 551A says. That's incorrect. And the last objection, well, another objection, 16. On August 17, 2022, DPW inspected an electrical service and passed inspection. I don't believe that was in evidence. Conclusion of law number 6, DPW has the authority to revoke any permit. That's not correct. It's qualified. And that's it. And we ask that the board accept and adopt the findings of facts, conclusions of law, decision, and order submitted by the county with that correction to finding of fact number 6. Thank you.
Thank you, Mr. South Ferguson. Does the board have any questions, comments, or, we're still in our discussion period? So what we're looking for is a motion to either adopt the DPW's findings of fact, conclusion, and law, the appellant findings of fact, conclusion, and law, or a hybrid, and we need a motion to start that off on what it is we would like discussion on.
I'll make a motion that we adopt the DPW finding of facts, including their amendments, clarifications.
I second.
Any discussion? Mr. Henderson?
Yeah, on the motion, I think that we want to call out the specific finding of facts that we're accepting in there. Unless you think that
Okay.
the broad general acceptance is of the director's proposed finding of facts is sufficient.
I've got a
Noah, do
question.
you have a comment? Go ahead.
Can we go, I'd like to go into executive session to kind of clear up a few questions in my mind about the motions before us.
So I need a motion to enter into executive session pursuant to,
Chair,
sorry, I gotta find it.
Chair?
Yes,
I would make a
ahead.
motion that pursuant to HRS Section 92-5A4, I make a motion for an executive session to consult with the board's attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities.
Thank you. I second.
All in favor?
Aye.
At this time, we will be going into executive session.
Give us just one moment while we set up the Zoom room for executive session. Oh, it's there, so those of you online, please click the join button.
And does
There we go.
Here,
Yeah.
there we go.
So now, but I'm
good.
I'm
Yeah,
good?
you're good.
Okay.
You have to just start.
Aloha, we're back from executive session and back in regular session for the Board of Appeals hearing on Friday, May 12th, 2023. I believe at this time, the board is still in discussion and we still have a motion on the table. And the original motion made by board member Scott Martin was to adopt the department's finding of fact, conclusion of law, decision, and order.
I'd like to make another motion to withdraw my prior position.
Can I get a second? Oh, I see Noe, you have to
I
unmute.
Second.
Okay, so we have a motion to withdraw and a second. Any discussion? Seeing none, can we take a vote on that withdrawal? April?
Yes. Mr. Martin,
Yes.
Ms. Psyche,
Yes.
Mr. Henderson,
Aye.
Ms. Chair,
Aye.
motion passes.
Thank you. So we're back in discussion. Any comments or discussion by the board, or we're still looking for a new motion? Mr. Henderson has his hand up.
Richard Henderson, and I'd like to make a motion that we adopt the following, which would be a hybrid of the two documents we have before us. I move that we adopt the following. One, from the director's proposed document, findings of facts number 1, 2, 3, 4, 6. And I would like to amend 6 by, after the DPW, deleting the period, adding a comma, and then the words "as to the 1987 permit." Number 7, I want to amend to read, on January 8th, 2020, the new owner of the property, Douglas Peterson, was issued a building permit to alter and add to the structure identified as building permit BK 2020-00049, otherwise referred to as the 2020 permit. And number 8, amend to read the following. The building permit application for the 2020 permit did not indicate that the 1987 permit was expired, had received any inspections, or that it received final approval. Numbers 9, numbers 10, amended to add "with the 2020 permit" from Mr. Peterson at the end of the sentence. Number 11, amend to add stating that permit number BK 2020-00049 for the alterations was issued in error, since the reference permit number 872263 was not granted a permit extension by the June 1st, 2022 deadline at the end of the sentence. Numbers 12, 13, 14, and then 14 striking everything after the word issued. From the appellant's proposed document, findings of fact number 21. From the appellant's conclusions of law, numbers 1, 2, 3, 4, 5, 6, amended to read DPW has the authority to revoke or suspend any permit when issued in error on the basis of incorrect information supplied or in violation of the construction code, any permit or variance issued pursuant to the construction code or other applicable law, HCC section 5-5-1 D2, numbers 7, numbers 9, and numbers 10. And from the director's conclusion of law, number 7. I would also like to add the following to the findings of fact. Number 1, the line on the 1987 permit for plumbing contractor states later. Number 2, the line on the 1987 permit for electrical contractor states no electricity. Number 3, Mr. Peterson testified that he knew that the 1987 permit was never finalized and remained incomplete. Number 4, Mr. Peterson testified that he never discussed the 1987 permit with the appellant. Number 5, at no time did any of the property's owners apply to extend the deadline of the 1987 permit. And that is the motion.
Thank you.
I would like to second the motion.
I have a second by Ms. Psyche. Any discussion by the board? Seeing none, I can, we vote first. Seeing no discussion on the motion, can I go to vote? April.
Mr. Henderson,
Aye.
Ms. Psyche,
Aye.
Mr. Martin,
Yes.
and Chair Aguiar.
Aye.
Motion passes.
All right, motion passes with the hybrid findings of fact, conclusions of law. And if I may ask our board's attorney to draw that up, since we are modifying both documents, if Ms. Tavares, you could
Sure.
please draw that up for us, and then we will be issuing it to both parties.
Will do, Chair.
Thank you, and that concludes this case. Thank you very much for your folks' time.
Thank you, everyone. Thank you.
Thank you. All right. Moving on to,
Okay.
thank you.
Thank you.
Get better.
Yeah, I hope so. Some people like me this way.
All right, if I may now read into the next agenda item, number 2, under old business, Board of Appeals Rule Amendment BOA-21-000299. Discussion about the potential rule amendments in accordance with Rule 5 of the Board of Appeals Rules of Practice and Procedure and Hawaii Revised Statutes, Chapter 91. HRS 92-2.5 permits this board to create an interaction group or a small group comprised of 2 or 3 members of the board that can investigate, make recommendations to amend the rules of practice and procedures. And the process to update the board's rules appears to have started in 2021, and I believe I was on the board at that time, and we did go through an editing process, but it has never been finalized. So it's still in draft form. So I would like to open up any discussions or thoughts or suggestions or input on this item. And again, the goal is to get our rules updated and to do so in the most efficient and effective way permitted by the rules.
Okay,
Possible to see a draft of the unfinished edit from the prior work, use that as a starting point.
Yes, I think getting into the details of how we will proceed on reviewing the current document and then incorporating comments from other parties, we can define that. But I think the first thing to do is first decide on the structure of how we would like to pursue going through edits and asking for feedback. And because if we don't or can't create a working group of less than quorum, so if we create a working group that consists of 2 or 3 members, we can be working on this outside of regular board meetings so that we can do our due diligence, gather information, and then that working group can present it in a published public meeting to the other board members, and then we can go into discussion and review. So it's not necessarily intended that we're going to come up with the amended document in a singular meeting. If it takes whatever due diligence it takes, we have time to hear the committee's recommendations or work that they found and then go into discussion and all of that. So I think that would, go ahead and Richie.
This is Richard Henderson. Chair Aguiar, I would like to make a motion that the board considers convening a permitted interaction group consisting of 2 or more members, but less than quorum, in order to review the proposed rules and policies of the appeals board.
yes, I second.
All right, I have a second. Any discussion?
I would like to be on that panel. I'd like to help work it out and learn a little bit.
Great. Yes, I too would like to be on that panel.
I think that's good, and I call for the question.
Both
Okay.
of you are in Hilo, right?
No,
No.
I'm in Kona. Any other discussion? No? Okay, seeing none, if we can go to vote on the creation of a permitted working group, who will then report back to the board on their findings and or recommendations.
Perfect. Mr. Henderson,
Aye.
Ms. Psyche,
Aye.
Mr. Martin,
Yes.
and Chair Aguiar.
Aye.
Very good.
Motion.
Passes, yeah.
Great.
And we have Ms. Psyche, yourself, Chair Aguiar, and is there one more member or just the 2?
That's
Just the
I think at this time, we have to leave it at 2. I think
Okay.
5 is our member, our board consistency right now.
quorum. Got it. Yeah, it's less than quorum.
We are allowed to have 3 because our quorum is 4, regardless of how many members we have at this time. So
Okay,
are we,
I'll serve on
we're
it.
allowed to explore that later, or we have to define the working group now?
So right now, we have 2 board members who volunteered to be part of the group. We can have a third member if either of you gentlemen want to be a part of it.
Yeah,
It is
I'll go on.
permissible because our quorum is 4. Even if we only have 4 members right now, this is separate from a board meeting. So there's not going to be any board action that's taken specifically within this group. And so therefore, the statute permits it to be a maximum less than quorum. So that would be a total of 3 board members. And myself and our staff would be a part of the group just to facilitate and to provide guidance and,
Yeah.
clerical and legal assistance to the group. So we can have up to 3 members maximum. Does that answer your question?
Yes.
2 is fine.
Me and Coach.
Throw me in, Coach.
Throw me in,
Wants to
okay.
be on panel.
Okay. Okay, perfect. And so the only thing that we would need to put on the record is what the board is expecting or giving the parameters of what the group is going to do now that we've created a group.
So the parameters or the expectation of our group would be to produce a recommended amended document and present to the group for discussion in a regular open session meeting.
Yeah, I would make a motion that the purpose of the permitted interaction group should be to review and propose updates to the current rules, and that we would then share those and provide to the board a draft of those recommendations for rule change.
Okay, do I have a second?
Second.
I have a second. Any discussion? Seeing none, let's go to vote.
Mr. Henderson,
Aye.
Mr. Martin,
Aye.
Ms. Psyche,
Yes,
Chair Aguirre.
Aye.
Great, motion passed.
Great, thank you.
Mhm.
We have a lot of work ahead of us.
We'll get through it.
Well, we do have a draft,
We do,
and
and
I
Yes, we
recall
do.
some I don't know what I'd call it, but mention in the past that each one of the rules needs to have the state Hawaii revised statute on the end of it as to its authority of being a rule. Is that your understanding, Sherry?
No, that's a little too intense. We don't need
Okay.
to, if, I'll guide you through it.
All right.
I think there are a lot of when we started this in 2021, one of the catalysts was because we had discrepancies in the document itself where the same statement was written differently in 2 different sections. So part of it was just cleaning up language where they were contradicting each other. The other was trying to also define some timelines that would help us get documents in a timely manner before a hearing. I think there's no threshold right now on what could be submitted and when. So it's a lot of it is stuff like that, is discrepancies in our own document. But for sure, I think our document that is currently posted on the county website is the starting point. That is currently what we're operating from. So, yes, we will definitely jump right in and start working on it.
All right, then you'll get the draft of the rules and policies out to the committee.
Yes,
Thank you.
and then we'll ping everyone on your availability, timelines, all that. Perfect. Okay, so we have a couple more items on our agenda. I'd like to move to approve the April 14th, 2023 meeting minutes, or may I get a motion to approve those meeting minutes?
I move that we
Mr.
accept
Henderson.
the April 2023 minutes as circulated.
I second that motion.
Any discussion? Seeing none. All in favor?
Aye.
Aye. Motion passes to approve the April 14th, 2023 meeting minutes. Moving on to administrative matters. April, do we have any status updates for outstanding Board of Appeals petitions?
Let me find my list real quick.
Okay.
Real quick. So we don't have any petitions currently scheduled for June. And we have 1, 2, 3, 4, 5 currently scheduled for July that'll still, you guys will do your briefing conferences for. Okay, so June looks like no meeting.
Okay.
Mm-hmm.
Perfect. So does anyone have any announcements or anything they'd like to make? Seeing none?
I can just
Oh,
let
perfect.
everyone know that we have received 3 nominations to fill the 3 vacancies that we have. So that process is going to start with the government committee on June 2nd, I believe. And so potentially by July, we'll have a full board.
Awesome.
It's really a rockin' July meeting.
That'd be great.
5 cases, brand new board members. Another,
I better get
I
those.
won't be the only neophyte.
We'll be fine, we'll be fine.
Anyone else? All right, can I get a motion to adjourn the meeting?
I move that, Psyche, I move that we adjourn this meeting.
Commissioner Henderson,
Can I get a
I
second?
second.
Great, all in favor to adjourn the
Aye.
meeting?
Aye.
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 Thank you all.
Discussion.
Thank
Great.
you. Have a good day, everybody.
Thank you.
Thank